Maine has a tenant protective late fee framework with a specific statutory provision that limits what landlords can charge. The governing law is found in Maine Revised Statutes Title 14, Chapter 710, which covers residential rental agreements, along with general contract principles and the state's consumer protection laws. If you're a landlord or tenant in Maine, the statute provides clear rules, and the state's overall tenant protective orientation means that compliance is taken seriously. Let's start with the key rule. Under Maine Revised Statutes, Title 14, Section 6028, a landlord may charge a late fee, but the fee cannot exceed 4% of the amount of rent due. This is one of the lowest statutory caps in the country. On a $1,200 rent, the maximum late fee is $48. On a $1,000 rent, the maximum is $40. On an $800 rent, common in many Maine communities, the maximum is $32. The 4% cap keeps late fees modest by design. Even in Portland, where rents have increased significantly, a 4% fee on an $1,800 rent produces a maximum of $72. In Maine's more affordable markets, the fees are even smaller. This makes late fees a minor administrative cost recovery, not a revenue source or significant behavioral incentive. Maine mandates a grace period. Under the same section, the landlord cannot impose a late fee until the rent is 15 days or more past due. If rent is due on the 1st, the late fee cannot be charged until the 16th. 15 days is the second longest mandatory grace period in the country, behind only Massachusetts at 30 days. The combination of the 4% cap and the 15-day grace period creates one of the most restrictive late fee environments in the nation. The landlord absorbs more than 2 weeks of delayed payment before any fee applies, and when it does apply, the fee is capped at 4%. For landlords accustomed to charging 5 to 10% after a 3 to 5 day grace period, Maine's framework requires a significant adjustment in expectations. The lease must clearly state the late fee terms. Under Section 6028, the fee must be part of a written rental agreement. A late fee that isn't documented in the lease is not enforceable. The lease should state the rent due date, the 15-day grace period, the exact fee amount or percentage up to 4%, and when the fee triggers. Maine's statute also specifies that the late fee is the only charge the landlord can impose for late payment. The landlord cannot charge additional administrative fees, processing fees, or other charges on top of the late fee. The 4% fee is the total, not the starting point for additional charges. Compounding late fees in Maine must stay within the 4% cap. Since only one late fee can be charged per late payment, and that fee cannot exceed 4%, there is effectively no room for compounding. A daily or weekly charge structure that accumulates beyond 4% violates the statute. The only compliant approach is a single fee at or below 4% of the rent due. Maine's Unfair Trade Practices Act, Title 5, Section 207, provides a powerful enforcement mechanism. The Act prohibits unfair or deceptive trade practices and applies to residential rental transactions. A late fee that violates the 4% cap, the 15-day grace period, or the single fee limitation can constitute an unfair practice. The Act provides for actual damages, injunctive relief, and in some cases, attorney's fees. Maine's Attorney General also has enforcement authority under the Act. The interaction between late fees and the eviction process in Maine is governed by the state's forcible entry and detainer statutes. Under Title 14, Section 6002, the landlord must provide a 7-day notice for non-payment of rent. The amount demanded must be accurate, including only legally compliant late fees. Maine's eviction process provides the tenant with an opportunity to cure if the tenant pays the full amount owed within the 7-day notice period. The eviction stops. The cure amount must include only compliant fees, fees that were charged after the 15-day grace period, that don't exceed 4%, and that were properly documented in the lease. Maine courts, particularly in Cumberland County and York County where most eviction cases are filed, scrutinize late fee compliance. Pine Tree Legal Assistance and other legal aid organizations regularly represent tenants in eviction proceedings and challenge non-compliant fees. Maine limits the security deposit to 2 months' rent. The deposit must be returned within 30 days, or within 21 days if the tenant has provided a forwarding address. The landlord must provide an itemized statement of deductions. Unpaid compliant late fees can be deducted, but the deduction must be itemized, and the fees must comply with the 4% cap and the 15-day grace period. Wrongful withholding can result in the landlord being liable for double the amount wrongfully withheld plus attorney's fees. For tenants receiving Housing Choice Voucher Assistance, Maine landlords cannot charge late fees when the Housing Authority's portion is delayed. Maine prohibits source of income discrimination under the Maine Human Rights Act. Landlords cannot discriminate based on the tenant's use of housing vouchers or other lawful income sources. Penalizing a voucher tenant for the authority's processing delay creates both a late fee violation and a discrimination claim. Maine does not have a significant active duty military population. No major installations are in the state. However, the Portsmouth Naval Shipyard in Kittery, technically a federal facility, employs both military and civilian personnel who rent in southern Maine. The Brunswick Naval Air Station closed in 2011, but the area has transitioned to civilian use. Various Coast Guard stations along the Maine coast generate some military demand. The SCRA applies to any active duty service member renting in Maine. From a practical standpoint, the 4% cap and 15-day grace period mean that late fees are a minimal factor in Maine landlord operations. The fees are too small and kick in too late to serve as a meaningful behavioral incentive. Maine landlords should focus on tenant screening and communication rather than late fee enforcement. Portland is Maine's largest city and tightest rental market. The economy is driven by healthcare, including Maine Medical Center, tourism, the food and restaurant scene, technology, and quality of life appeal. Portland has experienced significant rent increases driven by limited housing supply, strong demand, and the city's growing reputation as a lifestyle destination. Rents in desirable Portland neighborhoods commonly range from $1,500 to $2,200. The 4% cap produces maximum fees of $60 to $88. These amounts are modest relative to the rent, barely noticeable for a tenant who can afford $1,800 a month. Late fee enforcement in Portland is a minor operational detail, not a meaningful revenue stream. Portland has been active in tenant protection discussions, including consideration of rent control measures. While Portland hasn't enacted rent control as of this recording, the political environment signals that landlord practices are subject to heightened scrutiny. Late fee compliance should be treated as mandatory, not optional. South Portland, Scarborough, and Westbrook share Portland's general dynamics. Biddeford and Saco have growing markets with more moderate rents. Bangor, the largest city in northern Maine, has a more affordable market driven by healthcare, the University of Maine in nearby Orono, and regional commerce. Rents are lower than Portland, typically $800 to $1,200, and the 4% cap produces maximum fees of $32 to $48. Lewiston-Auburn has an affordable market. Augusta, the state capital, has a small, stable market. Brunswick has transitioned since the Naval Air Station closure. Bar Harbor and the MDI area have seasonal tourism dynamics. Maine's seasonal tourism economy affects late payment patterns in coastal and resort communities. Workers in the hospitality, restaurant, and tourism sectors may have strong income during summer and reduced income during winter. Late payment patterns may correlate with these seasonal shifts. Some landlords in tourist areas adjust their expectations seasonally, understanding that December through March may produce more late payments than July through September. The University of Maine in Orono creates student demand. Student late payments correlate with financial aid processing, but the 15-day grace period comfortably covers any processing delay. One best practice for Maine landlords: accept that the 4% cap and 15-day grace period make late fees a nominal tool. Do not build your financial model around late fee income. Set the fee at 4%, the statutory maximum. Document the 15-day grace period in the lease, and focus your actual late payment strategy on screening, communication, and the eviction process when necessary. Another best practice: never charge a late fee before day 16. This is the critical compliance rule in Maine. Any fee charged on day 14, even day 15, violates the statute and creates liability under the Unfair Trade Practices Act. Set your system to flag day 16 as the earliest trigger date. Build in a one-day buffer to eliminate calculation errors. A third best practice: given the very small fee amounts, consider whether late fee enforcement is worth the administrative effort for each specific situation. A $32 fee on an $800 rent may cost more to track, document, and potentially defend than it generates in revenue. For many Maine landlords, the late fee serves primarily as a symbolic consequence rather than a meaningful financial tool, and the real response to chronic late payment is the eviction process. For the complete guide to Maine late fee laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our late fee law series.